Hey, good morning, everybody. Welcome back to Law and Legitimacy, where every day is a new day, I think, So I begin day 3 of jury selection in a fraud case in Danbury, Connecticut. We'll likely wrap up jury selection today. And yesterday was just a blast. And so those of you listening obviously have some interest in law, or you wouldn't be listening. Some of you are lawyers and some of you aren't. I'm grateful to those of you who are lawyers who have written comments saying we should get continuing legal education credits for this. So this first segment is for you. And for those of you who aren't lawyers, I thought it'd be interesting for you to get some insight into what a lawyer does during jury selection. Jury selection is called voir dire, a French
Norm,
term.
before you do that, please, if you are, if you're watching the video now, please make sure you hit the like button, maybe share the stream, but definitely make sure you're subscribed. That's going to help us out tremendously. So sorry, Norm, to interrupt. Good morning, everybody. Good morning to you, Norm, and let's get it.
Yeah, maybe we should do that in the morning. Just say good morning to one another so you're not sitting there saying, what am I, a potted plant? Because I do have a tendency to get going. So voir dire, French term, V-O-I-R. There you go, D-I-R-E,
Yeah.
to speak the truth. It's pronounced voir dire in Connecticut. Out west, they call it voir dire. I don't know how it's done in the South. They probably just say, I don't know. But in any case, it's an opportunity to select from the community people who will serve on a jury. And the legal standard for selection of a jury is it has to be a fair cross section of the community. And in order to serve, a person must be ready, willing, and able to be a fair and impartial juror. That is, they must be able to listen to the evidence and decide it independent of bias, prejudice, or preconception. And the whole process of voir dire then is winnowing from a group of randomly selected people summoned to court, that is, ordered to come to court, a group of people who are willing to serve the difficult task of being a jury or being a juror. And I say difficult because, some of the cases that you will hear will change your life. I mean, trying them, as a lawyer certainly has changed mine. So what does a lawyer do in jury selection? Some lawyers try to indoctrinate jurors. They try to impose their will or their theory of the case on jurors by introducing themes that they will argue at the end of the case. Victimhood, for example, in a plaintiff's case, the desire for justice, in a prosecutor's case. But really, a juror's job is to decide the facts and to follow the law. And as a defense lawyer in a criminal case, you have a client who is facing jeopardy. That is, who is facing legal consequences as a result of that trial, whether it's the loss of liberty and or life or a financial fine. And so what you're looking for in a jury always and in every case are jurors who will listen to you. So forget everything you have read about jury consultants. Forget the jury consultants. Voir dire is about the relationship between a lawyer and the juror. And that is the beginning and the end of the discussion. And that relationship is defined in terms of bounce. And so what you want to determine is whether this juror will listen to you. And, the Martin Buber once wrote a book called I and Thou about the confrontation between two people and what it takes to have an intimate conversation. A trial lawyer is expected, at least a good one in my view, to have an intimate conversation about difficult topics in open court with a perfect stranger. And if you're saying, well, good luck with that, you're right, but it can happen. So let me tell you a little bit about what happened yesterday, because I think it's an interesting illustration of the risks a lawyer is expected to take and the reward that comes of taking those risks. I'm trying a fraud case in Danbury. It's 15 miles maybe from Newtown and the Sandy Hook Elementary School shooting. I represented Alex Jones, a controversial person, obviously, to people in Newtown. It's recommended by many folks that I don't stop in Newtown at any deli or restaurant for fear of what might remain in my food or might be put in my food, and I don't. So I get up yesterday on my feet, and in Connecticut, we have something called individual sequestered voir dire, which means we question each juror individually out of the presence of others and can talk to them for as long as the judge lets us. So it takes maybe a half an hour to go through a juror on an individual basis in Connecticut State Court. First juror out of the box is asked whether he recognizes anybody who names or people involved in the case, and he says, "I do. I recognize Mr. Pattis. I recognize Mr. Pattis from some of the cases he's had. The judge turns the Venire person, VENIREPERSON, the person on the Venire panel, over to me. And I walk up to him and I say, you recognize some of my cases. What cases are those? And he mentions a murder case that was quite controversial in Connecticut involving Fotis Doulos and Michelle Traconis. And then he mentions the Alex Jones case. And I said, well, I have received, and this was the unconventional piece of the voir dire. I want to invite him to talk about himself. And so I do so by showing him part of myself. The biggest mistake lawyers make in voir dire is talking at jurors. You can do this. You can do that. Right. Can you do this? Can you do that? You want them to tell you something about themselves. And as with any intimate conversation, it begins with your showing something of yourself. So I say to him, the Alex Jones case was a very difficult case, and it was a very difficult case for me. I have received thousands of hate letters and in communications as a result of that case, and I'm betting that you would probably agree with some of the sentiments expressed in those communications. Am I right? And he said yes. And I said, well, thank you for sharing that. But are you open to the possibility that in that case, I did my job and I'm like every other person alive who wants simply to be loved? And he paused for a moment and he said, yes. And it broke the ice. And we were able to have a very meaningful conversation in which by reframing, by sharing with him my experience in that case, he was able to share his reaction. We put it behind us and he's now seated as a juror in a criminal case. Sometimes the interactions are humorous. We had one young guy get on the stand yesterday, and the prosecution, it was the prosecution's turn to question him. And he says, what do you do in your free time? I don't want to mention the fellow's, well, it's on the record, but I still don't want to mention his job. He says, well, in my free time, I spend a lot of time answering questions on Quora, Quora. And the prosecution said, about what? Well, military and naval affairs. I'm very interested in that. And I also answer questions about zombies. And so at this point, everybody in the courtroom kind of, their eyebrows rose. The judge looked at me. Nobody wanted to giggle. But I think this person probably took himself off the jury at that point. So the prosecution walks by me, says, I'm not taking it. I said, oh, I've got a question or two. So I stood up and said to the guy, I'm an old man and the internet is a challenge to me. I don't do Quora, but I gather that's an online forum when you can ask questions of experts. Yes, he said. Well, and you answer questions about zombies. And did I hear that correctly? Yes. I said, I just have to know, are there really zombies in the world? And he paused for a moment. He says, well, no, not really. I just like to have fun with that. And of course, I was disappointed because I was hoping that he'd say yes. And then we could have a difficult discussion about how do we know other minds, how we know our own minds. Am I a zombie? Was the judge a zombie? But when he acknowledged that this was just sort of entertainment, I thought, we let him go. Third and final anecdote from jury selection. And this one was sad. And I think it sheds light on the cause of our troubles in this time. Young woman, 29, lives at home with her parents, has a routine sort of ministerial job performing the same task over and over again in a structured environment. And she's asked, what do you do in your free time? Well, I come home and I spend most of my time on TikTok. And I thought, wow, that is not a spiritually enriched life as far as I'm concerned. So I got up to question her about that. And lo and behold, she was a closed book. I had the impression that this was a person who was not open to experience, who was not perhaps open to taking in another's world, that what she was hooked on, as it were, was her reaction to electronic stimuli. But what's real in the world are other persons, other people, and I wondered what would happen. I'm not going to be the guy, but what will happen the first time someone touches her? Will it reach her heart? Or will that be translated into stimuli processed in much the same way that TikTok data is? Don't know the answer to that,
That's an interesting. Wow, that's thought provoking because there's a question here, and I don't think that this is sort of off topic, asking about body language experts to see if they're being honest and receptive to avoid your own bias. But
I want to talk about that in a minute. Well,
yeah,
keep that up there so we address that with
my
Marcy.
thought though is that in terms of potential juror bias, or when you're having these conversations, that's a different type of that's a unique juror in the history of American jurisprudence, in that prior jurors have not been exposed to the online world in the way that current jurors are, right? And so in a way, there's almost this lurking synthetic bias. Maybe there's something racking through the reels in her brain, that will at some point enliven some preconceived notion within the trial that you could never control for, right? And
I
maybe,
think that's right.
I mean, so it's kind of wild to consider that, her free time is that, and then she's closed off to talking about it. Maybe the greater balance of her reality actually exists online.
Well, the truly terrifying, the truly terrifying thing about it is Connecticut is unique in the world for having individual sequestered voir dire. That is the ability to question jurors one at a time outside the presence of others. No other jurisdiction gives that as a matter of right in civil and criminal cases than Connecticut. Usually you only get it in other jurisdictions, in highly controversial cases, a capital case, let's say. And I think the result is that when you have group voir dire, especially group voir dire conducted by a judge who says, can anybody, you can do this, can't you? Or is there anybody who can't be fair? That's a meaningless voir dire, because what that does is it takes at face value answers that people are given. It avoids the sort of I-thou confrontation or encounter, and it permits people to hide in a group. And so this TikTok user would never have been seen in that group. She would have undoubtedly not answered any questions because she's phobic to interpersonal contact. And you'd get a juror that reacted to things without really knowing what they were reacting to at all. Marcy says, do you use body language experts to see if they're being honest and receptive to avoid your own bias? I don't use experts in jury selection at all, Marcy. If I ever get O.J. Simpson as a client and he's got about $5 million to spend, I'll expert everything up. But most people rely on their lawyers. And Marcy, at Jerry Spence's Trial Lawyers College, it's now called the Jerry Spence Method. Back in the 90s, he used to teach, and when I became a faculty member, we used to teach a technique of communication known as mirroring. And so you begin by sharing an intimate detail of your life or of something that is unusual that you wouldn't normally throw out there, and then you open to the other person. You stand arms open, your heart open. And I can't write a book about what that means, but you know what it means. There's when you say hello to a stranger, you're usually guarded. When you say hello to a lover, you're not, unless you're pissed. And when you're trying to encourage intimacy, that is contact between two people, there's a way of communicating. Mirroring is a way of doing that. You let your body language mirror theirs. You show them something of your own and ask them in exchange to show you something of their own, an attitude. You'll know your spider sense will go up. It's not perfect. It may reflect your bias. You're right. But it's all we have typically in a low budget or modest budget case. And the fact of the matter is, while cases aren't about the lawyer is a communicative vessel. And so it's my responsibility on behalf of the client to make sure that that the jury hears me. And so jury selection, in my view, all comes down to one word: bounce. And the way you test the reality of bounce is ask yourself who you're drawn to in a crowd. You're drawn to a person with whom you resonate. And I can't give you a scientific definition of resonance, but each and every person listening to this broadcast knows exactly what I'm talking about. When that person resonates with you, you know you are heard. You give and you get in return. And I would call that an intimate communication. And so what you're striving for in voir dire is a sense of intimacy, a sense of honesty with the juror. And what you're evaluating is you're evaluating many things. The critical evaluation is, will they listen? And sometimes they can't because they have biases they can't set aside. Like one guy, with respect to the Alex Jones case, I said, did you follow any of the Sandy Hook shooting cases? Well, not really, but kind of. Do you know who Alex Jones is? No. Well, if you were, and I say to him, if you were to learn that I represented somebody in the Sandy Hook shooting case, might that affect you? Well, if it's that guy who was talking stuff, I just forget about it. Now that guy's not open to overcoming his bias. How do I know that? He said it with such energy and such disgust that the only appropriate response to him as a potential juror is farewell. And he was excused for cause because he would not be able to listen to me once he learned that I had a role in that case. And so we say of jurors that while everyone is summoned to jury service and everybody has an equal and opportunity to serve and an equal obligation to serve, not every case is fit for every person. And so some people are excused because of their biases, their inability to set them aside in their life experience. It's very, the number of people, I mean, for example, picking a jury in a sex assault case is extremely difficult. I had no idea just how many people had suffered sexual abuse at the hands of families and loved ones. And in Voir dire, when you ask people, this is a case involving sexual assault, is there anything in your life that would make it difficult for you to be fair and impartial? They'll hedge. Has anyone close to you ever been a victim of sexual assault? And sometimes jurors will just start to cry or to show a shock reaction because yes, they themselves or a loved one had. And in that case, it's probably asking them too much to be to sit on a juror and to try to be fair and impartial. So those are some anecdotes about Voir dire. I just was aching all night long. Mike said after the show yesterday, you were flat. You were distracted. You got, and it's the first time he kind of bitched me out about my performance here. So I thought, well, okay, I better dig a little deep and come up with something that people might be interested in. And there you have it.
Janet says there's no hiding from handwriting analysis. Were I a defendant, that's what I'd want. And why would she say that, Norm?
The only handwriting analysis experts that I have ever used are to determine whether a known sample of handwriting, that is something that came from Mike Boyer, matches an unknown sample, that is a letter that was unsigned with a name. Did the same person write it? And so handwriting analyses in that case and analysts in that case can determine a sufficient degree of similarity. Whether you can read personality characteristics into handwriting analysis such that you'd know whether a person were empathic, angry, a spitter, or a swallower. That's a whole level of experience that I am inexperienced with. But I can tell you that of the thousands of people that I have represented in criminal cases, perhaps hundreds of them gone to trial with, I've only had one or two people who could afford, who could contemplate even affording to hire a handwriting analysis on this level. Connecticut has a very robust public defenders system with, I don't want to say an unlimited budget, but not a limited budget, a considerable budget for the hiring of experts. I'm not aware that they have ever hired a handwriting analysis to learn about personality characteristics of potential jurors. So Janet, I love you, but you got to give me something to read, because much though I love you, I don't know what you're talking about. And I don't say that. I don't say that to criticize you. I say it simply to be candid.
Yeah, I think that what Janet is probably, well, a good psychological tool for the box. Have studied handwriting. Hold on, go back. Has studied handwriting and it's revealing. Learn yourself, Norm. And I think that I understand the proposition behind what Janet is saying. I have really good handwriting. I'll just leave it at that. It's always been that way. I've always striven for that, but I don't know that it, I've thought about exactly the proposition that I think Janet is making here, that it should reveal something about oneself if you can pay attention to, how you structure the way that you write, your attention to detail. Are you, sort of type A, da 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 da. I think that there's a lot there. However, I have plenty of friends who have, 135 IQs, et cetera, and have extraordinarily bad handwriting, right? And so I don't know that there's a direct correlation with intellect for whatever reason. There's the trope about doctors having really, really shitty handwriting, right? We know that. But that's not also to say that somebody with extraordinarily good handwriting is, on one side of that bell curve or the other. So I think, I would be interested, Janet, if you have any experts, I think that would be a great interview for us.
I do too. I'd love to do that.
I'd be fascinated to learn about that body of academia.
And Janet, I learn yourself, Norm. Janet, I please don't take my comment as hostile or defiant or defensive. I'd love to learn more about this. I just don't even know where to begin.
Well, in my case, it's genetic. My handwriting being good is not, I didn't do that. It's genetic.
No, we'll talk about what's yearning to come out of you from the
Road Trek Girl says, I watched quite a bit of Norm's Alex Jones trial. I became a big fan of his courtroom attorney skills. So glad to see Norm starting a channel and love his appearances on Laid Back Law. So thank you, Road Trek Girl, for the compliment. However, this channel is like 3 years old. So welcome.
Yeah. Well, it's 3 years old, but we haven't really pushed it until recently, and now we're trying to make a thing of it. So come on out and help us. Appreciate the nice comments.
It looks like, we've got a ton of comments coming in about on this topic of jury selection, voir dire. So I think that maybe we should reserve a show in the future, maybe a Q&A specifically on this, so that we can talk back and forth about it.
Well, and maybe a Q&A. I think it might be more interesting even than that to do a Q&A on what a trial is and what happens at trial. People love to watch trials, and I often don't know why. And here's that echo again. Are we getting it on the new mic?
I don't hear it from my end, but the chat will tell us.
So, I think a Q&A on what a trial is, the phases of trial, questions about particular trial. I've tried hundreds of cases, and there are those who say, I know what I'm doing in a courtroom, and frankly, I'm among them. So if you have questions about trials, you're a practitioner or you're give us a call.
Haley, Lawyer Will, and In the Cloud are saying echoes, so I'm not sure what to do with that at the moment. So Norm, I don't know if you want to try and unplug and just go, naked with your monitor mic. But of course,
echo still. Yeah, I guess I'm going to have to apologize. Apologies, everyone.
Look, we're troubleshooting, right? So we're working up the chain here. Don't worry about it. Echo. Marcy says Eric Huntley has had some interesting handwriting guys on. Found you guys there. Great job. Cool. Okay. Well, then we have some. Steve Hillier says Echo has arrived. So Echo Charlie Echo. Here we go. You want to transition, Norm? I think you're on mute. Unmute yourself and then come back to the party. There you are.
Here I am. So the sound quality is poor. We've gone through a couple of mics. I don't know. I give up. Hey, so let's talk about Jalapeño Jack. He's back. It's an interesting question. Judge Cannon in Florida wants to give the jury a preliminary instruction in the documents case involving Trump's retention of certain documents. And that would give them the ability to regard Trump's documents, the documents he took, as personal rather than government property. And that's a defense that the defendants want to assert. Smith thinks it's an improper defense and wants to prevent the judge from giving that charge. What does he do? Now, if a judge gives that, he's got a problem on his hands. You've all heard of the double jeopardy clause, meaning that a person cannot be tried twice for the same offense by the same sovereign. When does jeopardy attach? When does it become a thing? Jeopardy attaches when the jury is sworn, when a full jury is sworn. That's when jeopardy attaches. So what Jack has to be careful, because once a jury is seated, if the case ends in an acquittal, the government cannot try him again. That would be a violation of double jeopardy. If the case ends in a mistrial, no verdict, it might be able to be tried again only if the court made a finding that the mistrial was as a result of manifest necessity. A juror got sick or some extrinsic factor interfered with the unfolding of the trial process. If, however, there was an intrinsic difficulty, something happened in trial that caused the mistrial, there may or may not be a retrial. So Jack wants to make sure, Jalapeño Jack wants to make sure that the trial doesn't begin with bad instructions, because if it begins with bad instructions and Trump wins, he'll never get back at it. So what does he do? The government can't appeal from a loss at trial, because that would be a double jeopardy issue. You won, the jury decided, you don't get a second bite at the apple. So he's forced to use an unusual vehicle, and it's called a writ, W-R-I-T, of Mandamus, M-A-N-D-A-M-U-S. And what a writ of Mandamus is an order from one court to another court to do their job, as it were. And so in this case, it's expected that Jack will go to the 11th Circuit Court of Appeals and ask the 11th Circuit to issue an order to Judge Cannon not to give that instruction. This rarely happens. It happened to me in a very significant case in Connecticut that made its way to the United States Court of Appeals for the Second Circuit involving the topic of jury nullification. The case involved a young man named Yehudi, Y-E-H-U-D-I, Manzano, M-A-N-Z-N-A-O. And in Manzano's case, he was charged with having improper sexual relations with a minor. It found its way into federal court because he took a picture of the two of them and saved it on his phone. The phone traveled in interstate commerce, therefore satisfying the jurisdictional commerce requirement to make this a federal offense. And the image of the young woman, who was underage, was bounced into the cloud. And even though it was immediately deleted, that bouncing into the cloud availed itself of interstate commerce. And so the result was he was accused of creating child pornography in putting it into interstate commerce and using interstate commerce in furtherance of this crime. And the result was he faced a mandatory minimum of 15 years in prison, which I thought was just outrageous. The notion that he could face that much time for that conduct with the electronic devices struck me as a manifest miscarriage of justice. And so I asked the judge for permission to argue to the jury nullification. And jury nullification is that legal doctrine that says to a juror, even if the law fits, even if you find the conduct that the government has proven fits the law, you cannot find the person guilty here because of the injustice of it all, and you should reject the law and the facts. The federal courts are hostile to jury nullification claims, but hostile for not for good reasons. There has never really been a full-on jury nullification case heard in the United States Supreme Court. The policy against nullification arises from a case called United States versus Sparf, S-P-A-R-F, or Sparf versus United States, I can't remember, an old maritime capital case where people asked for, there was a dead body at sea, and somebody was thrown over a ship, and the government charged murder. The defense wanted lesser included offenses, and the judge wouldn't give him that. And in a throwaway line, a line that was not necessary to the conclusion the judge read, or justices reached, but was used to support it, something called dicta. Judges said it is a judge's role to decide the law and juries to decide facts. So from that throwaway piece of dicta, that throwaway line has developed a policy against jury nullification. I full on assaulted that, challenged it. And the trial judge agreed that there was something wrong with the manner in which the government was proceeding. And if I could develop enough facts, he would permit me to argue jury nullification. Well, all hell broke loose at that point. The Justice Department, the Justice Department in D.C. intervened and filed a writ of mandamus in the Second Circuit Court of Appeals before the trial began to prevent the possibility of an acquittal with what the Justice Department regarded as bad law. The judge in that case, Stephan Underhill, hired his own lawyer. I was representing Mr. Manzano, and we appeared in the Second Circuit to argue the case, where by a vote of 2-1, the Second Circuit said that the judge could not permit me to argue jury nullification under any circumstances. So it's an example of what a writ of mandamus is used for. It's a little bit of a discussion of jury nullification, which is a far more complicated concept than I've given you reason to believe thus far, with far more policy implications than we've suggested. But in the Jalapeno Jack case with Trump, Jack wants to do the same thing. He doesn't want Judge Cannon to give an erroneous instruction of law, an instruction of law which he regards as erroneous, because if she does, then then the jury will be given an opportunity to make a bad decision. They could acquit Trump, and the government would never have the right to take an appeal. So this is a classic example of when a writ of mandamus can be used. Mike's got a great definition up there.
Yeah. So for anybody who's interested in just looking up, foundations of law that are publicly available, the North Carolina School of Government, UNC School of Government, has a very robust archive of stuff. And so this comes from the North Carolina Defenders Manual, but this is available online via the UNC School of Government. Just wanted to throw that out there and use this as something to better explain with some citations embedded.
So I see we've more or less talked our way through our half an hour. Sorry about that, folks. We lingered a little longer on the first topic than I expected, but it turned out to be a more interesting discussion. Tonight, I'll be speaking at the New Haven Ladies Association at 7 a.m. Ladies Aid Association. The topic is statuary in American political life. In other words, the Christopher Columbus statutes and what their erection and their taking down means, what the current disputes about identity politics say about the American soul, and how it is we unite as a people. And I'm increasingly coming to the conviction that we do so by once again returning to a habit of prayerful reverence to religious institutions. And those of you who've known me for a long time would probably be surprised to hear that come from my mouth. But when I look at the course that American politics is taking and the disconnect, the cognitive dissonance between our rhetoric and the lives we lead and our longing, I can't help but wonder whether we've fallen into a sort of species of national idolatry, where each person is worshiping in a house of their own, but they're worshiping rather than a mysterious sense of the other, of God's presence in time. They're worshiping an image of themselves in time. And because of that, if we each seek to become a God in our own right, the worshiping of multiple gods creates nothing but conflict and dissonance. And so I begin to believe, and increasingly am of the conviction, that the United States needs something like a third great awakening, a return to religious foundations that is rooted in a sense of reverence for the other and a love of God. I remind all of you that St. Augustine's concept of sin is love of the wrong thing. And I pose and will pose tonight at the Ladies Association whether our time proves that we've all come to love the wrong thing. And that, as the great composer Handel once said in The Messiah, all we like sheep have gone astray. And then at 10, I'll be live streaming on Good Logic's The Following Pro. I gather he wants to spitball the forthcoming Donald Trump trial involving Stormy Daniels' hush money payments. And so we'll be talking a little bit about what to expect in that trial. So
yes,
if you didn't get in,
that'll be fun. I'll make sure we're working on details. I'll get all the links and whatnot circulated via our X channel at LawPod Daily this evening. But yeah, so Norm, you'll be a busy man this evening. You'll be speaking in person at the New Haven Ladies Association, and then at 10 p.m. Eastern time, you'll be live streaming with Joe Neerman, aka Good Logic, on what he calls The Following Program. So you can find The Following Program at The Following Pro on X. I've got that right there in the banner below. But I'll definitely be tuned in. I'll be sacrificing a little bit of sleep just to kind of come and hang out with you guys. And if you're around and you're available, not asleep, join in. Do hashtag AMF yo-yo or hashtag bounce. I kind of like that one too.
Yeah, well, I mean, look, I'm dead serious about the bounce concept. You know, I've taught at trial lawyers convention or gatherings around the country. The biggest thrill of my professional life was many years ago. I was asked to come out and speak with Tony Serra to the Idaho Criminal Defense Lawyers Association. They actually paid me to go out and hang out at Sun Valley for 3 days, and my instructions were to give my presentation, but then to hang out with people because they had an interest presumably in me. And so I did, and I had the time of my life. I've also had a chance to teach with Jerry Spence at Mount Palomar in California, which was great, and around various locations in the West. I usually avoid these opportunities, or have in the last 15, 20 years, on the theory that I'm a broken vessel and what do I have to say? But I think out of a sense of humility, I think we're all broken vessels.
And we have burned that sort of proposition to the ground, Norm.
Yeah, so let's move on and get going in a new direction. So AMF yo-yo.
AMF. And if you haven't already, make sure you're subscribed somewhere, whether that's on YouTube, X, or on Rumble at LawPod Daily, Law and Legitimacy. You can follow Norm at Pattis Norm on X. And if you're so inclined, you can follow me as well at Michael Boyer _ on X. We're here every morning, 8 a.m., Monday through Friday. And we'll be doing a little more of this. This is a really good pocket for us, and we've got a great response. So thank you, everybody, for being vocal about your interest in the jury selection process, voir dire, and the trial. Generally, we'll aim into that a little bit more, Norm. I think you've got a lot of jewels that you probably have yet to recognize that people would be interested in mining out.
All right. Well, AMF, yo-yo.
AMF, everybody. See you tomorrow, Norm.